The matter of Amedure versus State of New York. Counsel?
Thank you, Your Honors, and may it please the Court. Adam Fusco of the Fusco Law Office for the petitioner's appellants. I respectfully request 2.5 minutes for rebuttal arguments.
We'll see if we can time it that way.
Thank you, Your Honor. When the Central Board of Canvassers splits on the validity of a ballot, Election Law 92092G requires that nonetheless it shall be cast and canvassed. This usurps the role of the judiciary in its general original jurisdiction. It deprives litigants of their due process rights to review an administrative determination, and it violates the constitutional requirement for bipartisan action at boards of elections. The judiciary, under Article 6, Section 7...
Counselor, are you saying you only want bipartisan action when it comes to validating a ballot and not for anything else, or are you expanding your argument to those other actions?
92092G is anomalous. There is bipartisan action at every other step of this process when it comes to discretionary determinations by boards of elections. It is only at this step of the process where one commissioner may make a unilateral determination on the validity of a ballot, and it is no longer preserved for judicial review.
Well, what are the other examples of where you need action by both commissioners?
So at the very beginning of the process, for instance, under 9209 sub 2, when there is the decision on the registration of an applicant for an absentee ballot, there is bipartisan action.
Don't those things seem, and I agree, those are like those, don't they seem more objective, right? A signature match is harder to quantify. So if you could object to every signature match and then throw that into the judiciary, you would delay the elections for a significant period of time.
Justice Garcia, one of the factual inaccuracies of the appellate division was that this is limited to signature matches. That is simply not the case. Signature matches are one of the examples where commissioners may split on the determination of a voter
But aren't
ballot.
the other examples that are set forth, I take it you're referring to the curable defects, is that correct?
I am referring to the non-curable defects.
I thought that those require one and not two?
So, for instance, if there is an intentionally identifying extrinsic mark on a ballot, a voter has not just made a scrivener's error or a little mark to see if their pen works, but actually an intentionally identifying mark. This would allow one commissioner to split with the other commissioner, and that ballot would not be preserved for judicial review and would be cast and canvassed.
Right, that was what I was trying to refer to, perhaps not very artfully. But it seems to me that perhaps with respect to those other types of defects, that it is a lot less likely that you would have disagreement than you might with respect to a signature match, which I think, as Judge Garcia was suggesting, is perhaps more subjective, right, than these other types of defects.
Well, intentionally identifying marks have been the subject of much litigation under the election law, from Kolb versus Casella all the way up to most recently in the matter of Sullivan in the Second Department. So no, that does lend itself to a lot of litigation that would be precluded by this statute. And to go back to the part about when is there bipartisan action by the board, well, in any of those instances where there's a defective ballot that can be cured, there's a bipartisan determination on sending out that cure notice, receiving that cure notice, and then determining whether, in fact, that defective ballot has been cured.
So bipartisan representation equals agreement? Is that your argument? They have to agree on everything?
No, bipartisan representation requires bipartisan action. They do not have to agree, but what this statute does that is so offensive is that it takes one commissioner's say and makes that the ability to validate a ballot. There is no bipartisan representation without bipartisan action.
Doesn't this turn in part perhaps on what the default is? In other words, if the default is that a ballot is valid and one person objects and there's a split, then the pre-existing status of the ballot, which is that it's valid, it seems to me would remain the case. Doesn't your position turn in part on some assumption that we start off by presuming it's invalid, so we need 2 votes to deem it valid and not 1 vote if there's a tie?
No, I don't believe that there is a presumption that the ballot coming in is invalid. There's a presumption that the commissioners, as guardians of their party, have the ability to make a determination on the validity of that ballot.
But
And
you
that's-
agree then, I just want to make sure I understand your position. Do you agree that when a ballot comes in, that the starting presumption is that it is valid, and if a defect is identified, that then it might be rendered invalid or curable? But it starts out presumed valid?
That is true that when a ballot comes in, it may be presumed that it appears valid, but that's before there is the ability for the commissioners to review that. And that's where 92092G is so offensive.
So can I ask you for a moment about, sorry, right in front of you, about Section 8 in the Constitution? So my understanding is that comes from the 1894 Convention. And is that yours as well?
It is, Your Honor.
Okay. And so there's discussion from the sponsor there, Lauterbach, he's a New York lawyer, who says this provision has nothing to do with canvassing. He says that over and over. If that's right, then I think maybe you're left with your argument about separation of powers and the role of the Supreme Court, but Section 8 doesn't really read on this case.
I would respectfully disagree that Article 2, Section 8 absolutely applies to canvassing. In the
You
matter
mean
of-
does not apply to, you think it does apply to
That it
canvassing?
does. Because-
Despite his statements?
This is not about the time and the place and the manner of how people vote. It's about who votes. And when the respondents cite to the matter of Chadbourne or the matter of Stapleton, those don't have anything to do with canvassing either. This has to do with the canvassing of ballots, and there is, in fact, a requirement that at that stage of the process, that there has to be bipartisan action. That is the spirit of Article 2,
Would you say
Section
that the
8.
1938 amendment also reflects, what would you say about the 1938 amendment? Let me ask you that.
I would say that the 1938 amendment comes on the heels of both this court's decision in the Chadbourne matter and sometime before that in Stapleton. But it is our position that even with the legislative intent that is found in the annotations to the 1938 convention, that this area of the Constitution does in fact require bipartisan action. And I think that's reflected in Article 3 of the election law, it's Section 212, which says that there can be no minority vote at a board of elections to take action on a matter, that there has to be, in fact, a bipartisan or, 2 parties each getting equal representation. For example, in the matter of Graziano versus the County of Albany, the court held that the constitutional and statutory equal representation guarantee encourages even-handed application of the election law.
But I guess that's where getting back to the point Judge Halligan was asking about before. And if you agree that the presumption is the ballots are valid, and if you don't, you only have one, let's just stay with one, one canvasser who says, I think there's a problem with the ballot, I won't approve it as valid, isn't that just that what you were calling an irrebuttable presumption, a rebuttable presumption was not rebutted, as opposed to some other way of thinking about that action?
Well,
But
prior
the
to
challenge to the presumption has failed, which is different from an affirmative choice about whether or not the ballot is valid or invalid.
But I believe that the issue is that regardless of what that presumption or that irrebuttable presumption is, the matter is no longer preserved for the court's review. The tie should not automatically go to the voter. The tie should be reserved for the court. And that's what this court said in the matter of the New York City Department of Environmental Protection versus the Civil Service Commission. When an agency, an administrative determination, when an agency has acted illegally, unconstitutionally, or in excess of its jurisdiction.
Can I just see your light is on, I apologize for interrupting you, but can you just briefly address subsection 8E, I don't take you to be raising a freestanding constitutional challenge to that provision, but instead to be arguing that it plays into your argument about whether or not 2G violates separation of powers. Do I have that right?
So 920928 sub E would be the bucket that the invalid ballots would go into. Obviously, this challenge is limited to 92092G, but our position the entire time has been that the entire statute should be thrown out because it's not severable. I believe that this court, should it excise 92092G, would have to look at 2098E and put all of the ballots where the commissioners split into the invalid category so that they're then preserved for judicial review, which under Article 16, Section 106 of the election law would allow any of the candidates or litigants to bring a challenge within 20 days.
Why should the mail-in ballots be treated differently from the day of voting, where there's a presumption of validity?
These paper ballots, whether they're early vote-by-mail ballots, absentee ballots, special federal ballots, military ballots, have always been reviewed after the day of voting. Before Chapter 763
Just because it was done before, why shouldn't the voter have the presumption that their ballot is going to be counted, that it be treated the same as the in-person voter?
I'm not arguing that there should be any disenfranchising of the voter. Rather, I'm arguing that there should be enfranchising of all the voters. Only valid ballots by qualified voters should be counted. And so for any other voter who has their valid
So
ballot.
these votes should be treated differently, that's what you're saying, as opposed to the presumption of the day of voter. Theirs has a presumption of validity.
These-
That should not apply to these votes.
These ballots should be treated differently if there is a split by the commissioners on their determination. They are afforded a discretionary review by each commissioner at the Board of Elections, and should they split on the determination of that ballot, they should be preserved for review, and they should not automatically be thrown into the count and the canvas, which is what is so offensive about 92092G.
Thank you.
Good afternoon, Your Honors. Paul Darrow-Essian, Darrow-Essian, and Darrow-Essian on behalf of the Senate and Assembly minority leaders. Likewise, would like to reserve approximately 2.5 minutes for rebuttal. Going back to the intent of the framers in 1894, Your Honor, as Judge Egan pointed out in his dissent, the purpose of this and the intent was to make sure that one party did not get an undue advantage or leverage in the electoral.
Well, how is that the case here? Because it's neutral on its face. It's not saying any particular party gets an advantage. It's just if you don't have unanimity, the ballot is treated as valid.
Because
It could be either party's vote, right?
what happens is it is a process which is not complete until 2G is affected. Once there is a dispute, one commissioner has the upper hand. It's so far so good, as Judge Egan said, in this statute until you get to this next step. Because this didn't exist before, this statutory framework creates more steps in the process, which is fine and good until you get to the fact that it permits the one commissioner to qualify a voter and make valid, which is the language of 2G.
But what I'm saying is, how is that partisan? I thought you said that was partisan.
Because it allows one commissioner to make the decision.
That could be either party, no?
Pardon?
It could
Of
be
other-
either
Yes,
party.
yes, absolutely. Absolutely. Either party, and
Yes.
this is the problem. And it's not necessarily malicious. It can be negligence also, because even the Gross case, which was before this court, involved two commissioners making a bipartisan mistake. And that happens. It showed up in the Tenney case, bipartisan errors. And it can be negligence, it can be, or intentional. So for example, a signature comes, there's no signature on the envelope. It comes back. That's clearly not a valid ballot, but a commissioner can say, I don't care, we're going to count it. Or I'm here today, my colleague is not here today. And so it's because there's no presumption involved here. I think that's one thing I would also point out, that a valid or invalid at the 2G step. it's still not over.
Counsel, if I could just go back to that last
Yeah.
part that we were doing, because I'm having trouble following the argument. Even if, as you say, one commissioner gets an advantage or an upper hand, with respect to the facial challenge, that applies to both commissioners. You know, the person claiming the invalidity has no more power regardless of which side they're on in terms of political party. So I don't understand the essence of the facial
Because
challenge.
one commissioner is validating what may be an otherwise invalid ballot, for example, no signature.
But that cuts both ways.
Pardon?
That
Sure.
would cut both
But
ways.
that's why you have a bipartisan system in this state, historically and constitutionally, so that one commissioner doesn't have that power to qualify
So
or
it
validate.
means, it means that they have to both agree.
Yes. Yes. And if they disagree, that's when it falls, I would argue, into subdivision 8, as Mr.
So
Fu-
the equal representation spills over to, it has to be
That's right.
an
It's not a valid
agreement.
ballot anymore. So the question is, what would happen if we invalidate that? I believe the statute provides for a mechanism of handling it, which is subdivision 8, as to other invalid ballots which get put into that bucket also.
Counsel, what would happen, just because I'm somewhat unclear, if you had one of these envelopes, I guess it is, with no signature? What happens to that?
So the cure notice goes out, and that's one of
Right.
the newer provisions of state law, which is
So
wonderful.
that's a curable defect.
Curable defect.
So it gets put aside, notice goes out.
Yes.
What if there's no response?
If there's no response, it's still sitting there, a commissioner can validate it and say, I
One
don't-
commissioner.
One commissioner can. That's the problem.
By saying what
By-
in that case?
By saying
There's no
it's okay.
signature.
One commissioner says, that's no good, there's no signature, clearly bad. The other commissioner says, I don't care, it's okay, it'll get counted. And that's true with any of the defects, whether they're the curable defects
Yeah.
that we were listing, or it could be a defect in the envelope, it could be that the voter is dead, for example. The voter is registered and voted in another state, and that's before, and there's information to that effect.
And that's done on the curable defects now. Let's stick with no signature. Nothing comes in by Election Day. When is the determination made as to that ballot if no response is given?
It's by law, by 2G, it gets counted,
When?
right, within 4 days
Of,
of coming back.
but let's say it's a curable defect, you send a notice out to cure, nothing comes back.
Within the statutory time period that the state or the board has set, then it gets counted. That's the problem. That's why it's a good statute up until that point.
So the 1894 convention also had a discussion, the 1894 convention
Yes.
record also has a discussion about the possibility of ties, right? Are you familiar with that?
I'm not familiar with that discussion. I did look at
Yeah.
the book in the last week or two.
Yep.
I don't recall that
And
discussion.
there's some back and forth where there's Mr. Dean and another delegate who are complaining this could result in ties, and that's a terrible thing. And then several other delegates say, well, that doesn't really happen very much in practice, and in any case, this is a better system. So there's at least a reading of that history that says they understood there could be a tie, and they decided not to resolve that in Section 8. So if that's right, and hypothetically, if that's right, then what does that mean as to a constitutional argument you'd make on the basis of Section 8?
I still think it gets back to one commissioner having the upper hand over the other, which is a dangerous precedent and goes against the interpretation of Article 2, Section 8 by this court in Graziano, which said, look, bipartisan representation leads to bipartisan action because of the guarantee of bipartisan representation. It wouldn't have meaning otherwise, and that's why
Well, if their view was that 99.9% of the time this was never going to be a problem, they could still say this bipartisan representation has tremendous value, and we recognize there's going to be some ties.
it would be meaningless. And again, we're looking at one, this
Why,
is,
why do you say that?
well, because it would open the door to any provision of election law, the issuance of ballots, which right now requires bipartisan action. You could have a similar provision that says, you know what, it's okay if one commissioner says it's okay to send a ballot to this person. Once you allow this, it allows any other section that has bipartisan requirement affixed to it to be changed also.
Well, I thought that your problem with regard to this specifically was that there was no opportunity for a court to intervene, whereas in the example
That's
you just
correct.
gave me, there, I assume, would be.
No, there wouldn't be. I'm saying it opens the door to a similar statutory structure that would dismantle the constitutional guarantee. if upheld.
So focusing on what is before us, which is the signature match question, if I'm understanding correctly, the signature is on the outside of the ballot envelope, is that
Yes.
right? So there's an envelope
Yes.
which comes in the mail, which is the same kind of envelope that you or I would use to send any letter via the mail. I understand it comes from the Board of Elections. And inside that regular mail envelope is a ballot envelope. There's a signature on the ballot envelope, and the ballot envelope is sealed, and the ballot is included inside the ballot envelope. Is that correct?
I believe that's correct, yes.
Okay. And I assume, just as a voter, but tell me if I'm wrong, that there is no identification on the ballot itself as to who the particular voter is.
Correct.
Right,
There should
okay.
not be. That would disqualify the ballot.
Right, right, for all sorts of, I think, probably plain reasons. So I would assume then that when the commissioners are looking at the ballot envelope and engaging in the signature match process, they have no idea what the vote is inside that envelope. Is that right?
Presumably.
Well-
Maybe we're wrong about that.
How could they?
Well, if Del Vermo knows that a certain political operative has just accumulated 50 ballots, and he knows from the list these 50 ballots come from the political operative, then he may have an idea, or she may have an idea, where these votes are.
So wait, just to make sure I'm clear, so these votes don't come in the mail? How are they
They
accumulated?
can come back in the mail, they can be dropped off by third parties or by the voter himself or herself.
And so is there any reason to think that the ballot commissioners would know what the substance of the vote is, who the person voted for, simply by looking at the signature?
But by the ballot, yes, because you know who the voter is. It's identified on the outside.
No, I'm sorry, I'm asking a different question. When the ballots are accumulated and then the review process commences to check the signatures, I don't understand how a commissioner could deduce who any particular ballot would list, would vote for, just from looking at the signature match.
If you have the list of who accumulated the third party, and there's been litigation and criminal charges over this type of thing, then you do know who these operative collected ballots from. Now, I don't think that's necessarily normal. I'm not saying this happens all the time, but in close elections, it can make a difference. And the assumption of your question, this is not, the validity of votes on Section 2G is not limited to signature matches. It is whether the voter voted elsewhere, registered elsewhere, is deceased, is the imperfections and deficiencies in the envelope itself.
Can you just go back for a second and define who accumulated the vote? That was the phrase you used. Are you implying, or are you not implying, are you saying that there are political agents who go out into the world, rally ballots, collect them, and then drop them off?
It's called the harvesting of ballots. It is a legal technique in New York State.
Okay.
Rightfully or wrongfully, that's.
I just want to know if
Yes,
it happens.
Yes.
And are you further stating that the commissioners know when they get an envelope, and let's say there's an issue with the signature, it's not there, or it doesn't seem correct, they know where that ballot has come from, whether it was one of those
They
harvesters?
could, because the lists are prepared in advance, and parties have access to that. Commissioners and political operatives do. And that's perfectly legal in this state.
If I
Thank-
may ask,
oop,
may I
sorry,
just ask if you could
Yes, Judge
take
Rivera.
30 seconds to address the agreement issue?
About the what?
The agreement issue that the Attorney General raised
Sure, the agreement issue.
regarding your clients? Yeah.
This was not raised down below,
Okay.
number one. It is, certainly it wasn't applied to respondents who were appellants in the appellant division. And also, the whole language of what an aggrieved party is basically someone who doesn't get the relief that he or she wanted. And we certainly fit in that category. We did not get the relief that we sought in the appellate division. And I think that broad definition, which again, I think the case is Ross v. Wig.
Well, you
said-
supported the plaintiffs, but you didn't actually seek
Well,
affirmative
there's a
relief,
difference
correct?
in our position.
Okay.
There is a difference in our
Okay.
position. We don't throw out the whole statute. here.
On the severability, okay.
Yes.
Yes.
So I would argue that they were,
Partially supported the
That's right.
plaintiff's position, but you didn't ask for affirmative relief in the truest sense, right?
only to the extent that we want to throw out that subdivision. But I don't think it's in a timely fashion, and the reality is, as in Silver v. Pataki, the result of this decision of this court, I think, would still be the same regardless of whether we are an aggrieved party or
Yes.
not. And I think that was the language in Silver. Yeah, the results of the court's decision will be exactly the same whether or not the claims are dismissed. Thank you.
Good afternoon, Your Honors, and may it please the Court, Sarah Rosenbluth for the State of New York. As the Appellate Division correctly held, Election Law, Section 9209-2G, is constitutional. Section 2G's presumption of validity is a permissible default rule for breaking ties that will inevitably arise on canvassing boards that are required to have even numbers of members.
Counsel, I'm sorry.
Is 2G more expansive, I'm sorry, than just the matching of the signatures? Is it as expansive as your colleagues suggest?
It's a little bit more expensive. If I could just sort of explain quickly how this scheme works, I think it will answer your question. So Section 2G is one of two different default rules that the legislature has prescribed for canvassing absentee ballots, and these default rules actually cut in opposite directions. So the first default rule is prescribed by 92092A, which governs the first step in the canvass process. At this first stage, canvassing boards review ballots for certain threshold defects that are presumptively disqualifying, such as whether the voter is registered or whether the ballot envelope is completely unsealed. If the board splits at this step, a presumption of invalidity arises, and the ballot is set aside for post-election review. So Section 2G, in response to Judge Singas, Section 2G's opposite presumption in favor of the ballot's validity only applies to any residual question of validity that might arise after these initial hurdles have been cleared.
So all of
What
the
about a curable defect?
Is that the
like
same
a
as
no
curable?
signature, and you send out and it doesn't come back, nothing comes back, but there's no signature. Now what happens?
So nothing happens, and this is a point that I'd like to clarify versus what my opponent just said. If a ballot comes back with no signature, that is a curable defect under 3B. So the cure notice goes out. If the voter ignores it and doesn't send back a ballot, there's no opportunity to take any further action.
It's done.
It's done, correct.
And how about what's called a preliminary invalid envelope that's set aside? What's that?
So those will be revisited at the post-election meeting.
What would an example of that be? What reason would you get put in that bucket?
So if the voter is not on the list of registered voters,
I'm sorry.
if the voter is not on the list of registered voters, if the ballot is completely unsealed, if it's not timely received, those are
That's
all.
a preliminarily invalid?
And preliminarily and really presumptively invalid, and that's articulated in Section 2A.
And what happens to those? That's a presumption that they are invalid, and if one commissioner votes for invalidity, it's done.
Correct. And really, I think the only way that it would then be counted is because there is an opportunity for judicial review after the election with respect to those
What-
ballots, so, yeah.
Can you explain what the interplay between 2C, which looks to me like it governs the signature match,
Yes.
and 3B, which lists a number of curable defects, including Romanet 2, which says the signature doesn't match? Is that the same process, but
I
referred
think
to in
so.
different places?
Yes, I think it's the same process.
So it's just the drafting is maybe not completely
It
precise.
sort of discusses that process in a few different signatures, but I think that 3B is referring to 3B Romanet 2 is sort of referring to the end result of 2C.
And with regard to the hypothetical that your adversary was laying out, so if in fact one of the canvassers was able to deduce because of access to whatever list, what vote was likely in an envelope because of where it came from, and there was some disproportionate or apparently disproportionate signature match violations called by that person. Is that something that could be litigated as a procedural irregularity? What avenues are available if there's
That's exactly right. So one thing I'd like to emphasize here is that this entire process is transparent. Representatives of candidates and political parties have the right to be present at every stage of this process. So if there is some sort of systemic corruption happening that they're sort of positing, you would expect to see some evidence of that with, by the third-party observers. They could observe this and then file an affidavit in court and go to court under 16-106-5 to seek an immediate injunction upon clear and convincing evidence of procedural harm.
But ballots that have been accepted can't be
That's
uncounted
right.
as a result of that,
That
right?
is correct, yes. I mean, admittedly, there is a certain amount of, you can't unring the bell, but prospectively, if this is happening in real time, you can run to court and say, hold on, there's something really bad happening, and then the canvass can be halted pending a review and further investigation into this credible allegation.
And
of
so
fraud.
your view is that 2G does not impinge upon the procedural irregularity recourse, understanding that it probably needs to be something more than one instance
Right.
for it to be procedural as opposed to
Yes,
singular.
because the procedural irregularity recourse is part of the same overall amendment of this statute. So yes, they definitely coexist.
I'm sorry to ask you to go back, but I just want to make sure that my notes are clear with respect to your response to earlier questions about the curable defects that don't get cured.
Yes,
They come back.
sorry, that don't get cured.
Don't get
Okay.
cured, yes. I thought their position was it gets counted. And I think your position is it does not get counted.
That's
I just
right.
want to be clear.
If there's a determination that it's defective, albeit, it's subject to a
It could have
cure,
been cured, but it was
But
not.
then it was not cured, then it
Doesn't
wasn't
get
cured.
counted.
is
It
that-
goes into some other pile.
Right, then there would
Well,
be
is-
nothing operative before the board anymore because it would have been deemed invalid. It would be waiting for a new ballot to come back from the voter and nothing would come back.
If that voter didn't cure beforehand but shows up to vote, could they, if they could say that is my ballot, or is there some way to match?
That's a good question.
Or at least they would never have been marked as, if it's the kind of cure that they're not marked in any shape or form.
I think what would happen is because part of this new reform is that if anyone is issued an absentee ballot, they are not then permitted to show up and
In
cast
person,
a ballot
right.
in person. They would be permitted, I believe, to cast an affidavit ballot if they showed up in person, and then that would be reviewed at this post-election meeting as
I see.
well.
So
Yeah.
to be clear, the ballots with curable defects are not counted because I take it they're sent back to the voter, so there's therefore no ballot in front of anyone to count, if the voter does not return it cured. Is that correct?
Right.
Not because there's some determination to set it aside and sequester it someplace, but hold on to it.
Yeah, I mean, technically, is the defective ballot sent back to the voter? I'm not exactly sure. I think it probably is. I mean, but the bottom line is that if nothing comes back from the voter, there's nothing to act upon any longer. Does that
Just
answer
one more
your
question about this
Okay,
area that
sure,
I know
yeah.
is kind of off the menu.
No, it's confusing, I understand.
But if I understood you correctly, if a voter goes in person to the polling place on election day, says, I'm here to vote, and they're informed for whatever reason, you can't vote because you voted by mail because they had requested,
Right.
or maybe someone else requested a mail-in ballot for them, they still have the right to cast some sort of provisional,
An affidavit ballot.
an
yes.
affidavit ballot.
Yes.
So once the issue is resolved, how does that work with the no uncounting provision? Oh, that ballot would have never been
It wouldn't
counted.
have been counted yet, and that's part of the pile that's reviewed at the post-election meeting under 8, subsection 8.
So if I can, I was not really asking about sending the ballot back to the voter and then it never comes, so what is there to count? I was thinking more of something is sent back, but it does not cure the defect.
Yeah, I mean,
Let me just say, if there's still a window, would that perhaps be sent back again to
I
the
think it could
voter?
be, because if a new ballot comes back, you're sort of
Going
reviewing
through
it
the same
fresh,
process,
and
but
there-
time still permits?
Yes, I believe so. I believe so. So another point that I wanted to address that my opponent made was this idea of unilateral action, that if the partner, assuming a two-member board, if one of the partners kind of walks away or goes to the bathroom, that someone can just like quickly unilaterally count them all himself. That is not correct. The statute certainly still contemplates bilateral action by an equally representative board. It just also prescribes a rule for breaking any ties.
Does it require agreement?
No, it does not require agreement. There is this presumption of validity, and
It's just the opportunity for both sides to actively participate in the process?
correct. And as one judge noted earlier on, I forget exactly who, it does provide equal opportunity for members of either party to raise an objection. It is completely agnostic as to the identity of the objector or his party affiliation.
So you view it as presumption, that's a default, and there is an opportunity to rebut, we'll use that word right now, presumption that fails. Is that how you view it?
I'm sorry, can you
Well,
repeat
there's
that?
an opportunity to rebut the presumption, but it fails because you've only got one vote.
That's right, that's right. And another point I'd like to make is that this actually exactly is the same presumption of validity that applies to in-person voting. I think Justice Troutman mentioned this. So this has been really how it's worked for in-person voting as long as I am aware, which is that if someone appears to vote in person and another person is there and objects to that person for whatever reason, they're not who they say they are, they've actually moved out of state, then the bipartisan Board of Election Inspectors is required to administer the voter an oath, whereby they attest to their qualifications. If the person completes the oath, he shall be permitted to vote, full stop, regardless of what the bipartisan election inspectors believe, and even if they're split as to whether to believe him. And that is because,
Sorry, I was just asking, do you want to address the judicial review point, why this is a permissible incursion on the right to get review from a court?
yes, so there is no inherent judicial, sort of mandatory jurisdiction in this area. The legislature has plenary authority over the conduct of elections and has express authority under Articles 2,
Do you think
Section
that the
2.
legislature could abrogate the authority to contest procedural irregularities, no matter how blatant?
I think it probably could. I mean, but that's the important point here, is that it hasn't, and there's
I
a
understand.
panoply of other remedies available throughout the election
But if we
law.
decide on your plenary authority point to agree with you, then they could do that.
I think hypothetically, I don't think that review for procedural irregularities is constitutionally
So
required.
let's say now a party comes in and says, Judge, you don't believe what's going on there. They're saying votes that aren't signed, ballots that aren't signed, they have a signature. Yes, it's a very nice signature, and now they're getting counted because they say it's a signature, and one of them can do that. What power would that judge have now to get involved in that?
So the judge could order a halting of all further canvassing. It could order some investigation to take place into these allegations.
And they would have authority to do that under the current law.
Yes, yes.
And do you want to touch on the aggrievement as well? I see your light is on.
Yeah, so the aggrievement, I think, I would just say quickly that the circumstances of this case, the procedural posture is really on all fours with the Burns case that this court decided a few months ago. The minority leaders did not seek their own relief. They never filed a motion or asserted a claim in Supreme Court. They merely supported plaintiffs and filed memoranda on their behalf. So when the appellate division ruled in our favor, they weren't actually denying an actual motion or claim that the minority leaders had made. So in a technical sense, I mean, although they would have preferred a different outcome, they're not technically aggrieved, and this case just procedurally is exactly on all fours with the Burns case.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Benjamin Idle from Hacker Murphy LLP for the New York State Senate Majority Leader and President pro tempore of the Senate. Off the top, I would just like to clarify one thing. The question has been asked a few times, what happens with a ballot with curable defects that is not timely cured? That's answered definitively in the final sentence of subdivision 8A, which says those ballots go in the same bucket as the ballots that displayed non-curable defects. That is, they're set aside and held for review within 4 days after Election Day and are not counted unless an order of the court says they are to be counted, okay? Turning first briefly to the Article 2, Section 8 argument, plainly, equal representation does not mean unanimous agreement or bipartisan agreement. It can't mean that.
Well, does it mean an equal vote?
It means equal participation.
Well, participation, but, I mean, do they have a right to vote?
They have a right to be heard, but in the case of a split over a ballot that is free of non-curable defects under 2G, in the event at least one of the two canvassers approves it, it goes through.
Yeah, I guess I'm struggling with right to be heard by whom? I mean, they're the only ones there.
Yeah, by their colleague.
They either can, so is that different from voting?
It's not voting, it's deliberating, right? We have a system, the Constitution appoints two arbiters, one from each party. That's what Article 2, Section 8 says, right? Bipartisan representation, they both have to be there. One cannot proceed in the absence of the other. They have the equal opportunity to try to persuade each other, equal opportunity to be disappointed by failing to sway the other in some cases when that happens. But that is representation. I submit that if...
That sounds like a lot what the seven of us do, and we think of it as voting.
Well, but sometimes you're going to have a split, right? And this is about what happens when there's a split. If the two of them agree, you could say it's a unanimous vote, okay? But here's what I'm talking about. This court said in Chadbourne, all right, that this section of the Constitution, all that it guarantees is representation of the two majority political parties on all election boards and nothing more, okay? And there has been a convention since then. The framers did not see fit to revise the language to clarify it. I submit that if the framers had intended for there to be unanimous agreement, the Constitution would say that. It would not be subtle about it, because that's a very steep test, all right? Furthermore, since People ex rel. Stapleton, there's been a long tradition in this state of a presumption of validity. In that case, the respondents, who were Republican poll inspectors in the city of Troy, expressly argued this equal representation point. That was their defense for not certifying the election results, because they objected to some in-person voters who they thought were imposters, even though they signed the required oaths. They said, because we disagreed, it was not equal representation, therefore invalid. This court rejected that squarely in Stapleton, which gives rise to a presumption of validity, which is evidenced also by Election Law 8504 and 8506. 8506, the predecessor absentee ballot that existed and governed this process for decades, when this canvassing of absentee ballots occurred at polling places, specifically requires that it takes a majority vote to reject a ballot, not a majority vote to accept it. If there's a split, the vote is accepted. The in-person canvassing statute, 8504, also does not authorize any side's poll watcher or poll inspector to unilaterally disqualify a voter. If that voter signs the statutorily prescribed affirmation, they're allowed to vote and the vote is counted. The law relies on other instruments, such as criminal liability and other deterrences, to guard against that sort of voter fraud. I also want to stress this point. If we accept the plaintiff's argument that the text, the words in Article 2, Section 8, equal representation, that means bipartisan agreement, the consequence of that will not be limited to absentee or mail-in ballots, because Article 2, Section 8 is not limited to the subject matter of absentee or mail-in ballots. That section says that all laws regulating the receipt and counting of votes have to involve equal representation. So if we are going to interpret today...
So you're saying it would apply to in-person voting as well?
It would.
So a single poll watcher on Election Day could stop someone from voting?
Exactly, which is certainly not in line with the expectations of voters. Very few people are accustomed to going to a polling place and have to secure a unanimous verdict of people of two different parties to let them vote. And it's not responsive to the spirit of what the reasoning of the presumption of validity set forth in Stapleton, where the court wrote, "The right of suffrage is one of the most valuable and sacred rights which the Constitution has conferred upon the citizen of the state." That's why the court decided that the lesser of two evils, if you will, the better path is a presumption of validity rather than invalidity. As to judicial review, my colleague covered it well, so I'm not going to rehash, and I only have 1 minute remaining, so I'm not going to rehash the availability of review under Election Law 16105, but I would like to briefly comment on authorities relied on by the plaintiffs for the suggestion that there must be judicial review. These are the Pan Am case, the Baer case, the DeCusman case. All those cases involved administrative proceedings in statutory schemes where some kind of administrative decision was insulated from judicial review. I note that in none of those cases did the court strike down the statute as facially invalid. In none of those cases did the court utter a prohibition against the limitation or deletion of judicial review over administrative relief. These were as-applied cases, not facial challenges, and in them, the court said that the as-applied burden is to show that the defendant agency is guilty of some unconstitutional or ultra vires conduct, an exception which this court described as extremely narrow in the case referred to by counsel for the plaintiffs. That's New York City Department of Environmental Protection versus New York City Civil Services. Okay, it is, in this case, there's nothing unconstitutional. My light is on, I see, so I'm going to stop going. But thank you for hearing me.
Thank you.
Yeah.
May it please the court, my name is Chris Massaroni from the Hodgson Russ Law Firm on behalf of the majority of the Assembly. I would submit to the court that the question of does equal representation really mean bipartisan action in all cases is actually answered in the Constitutional Convention reports, which I have read, Your Honor. And the very question was posed by one of the delegates who posed the question of what happens if a man comes to vote and there are 2 votes in favor and 2 votes against. In the following dialogue, so the delegates actually recognized this question that we're talking about and spending so much time on. It's 130 years ago. It's fascinating that they recognized it. So they recognized it, and the answer was that the man
Can swear out an affidavit ballot.
the equivalent of an affidavit ballot.
Yeah.
The language is a little arcane. It says that if they then vote to sustain the challenge or not sustain it, the man votes as he likes. The other thing that the delegates recognized 130 years ago is one of the topics that is raised by the opposition, that all disputes should be decided by judges, that if the 2 commissioners can't decide, give it to a judge, give it to a judge, give it to a judge.
Well, we kind of like that rule, but
Well, Your Honor, I'm not sure you'd want the courts to
Counsel,
be looking at
where
all.
would you put the limit on that? So how far with this plenary power could the legislature go in limiting judicial review of administrative action?
Your Honor, if I may just...
And I know this is not that case, but just could you answer that? How far do you believe the legislature could go in limiting judicial review of administrative action?
If I may just finish the point and then come back to that, Your Honor. The delegates said, one of the delegates, Mr. McLaughlin, said, in response to this question of judges should decide, Mr. McLaughlin said, does the gentleman mean to say that the justices of the peace are any more honest or better prepared to supervise elections than inspectors? So he asked a sarcastic question.
McLaughlin was a member of the legislature?
I'm sorry. No.
So going back to my
I
question,
meant those.
how far do you think the legislature could go in limiting judicial review authority?
Your Honor, I think that first of all, we have a whole body of jurisprudence and constitutional provisions that give authority to the legislature to prescribe and supervise elections. In terms of precisely where the line is drawn...
Constitution give us? What does the Constitution give the judiciary here?
The Constitution gives the judiciary a backstop to protect against constitutional violations. And I'm not sure where that line is drawn. I'm not sure what set of facts there might be, but they're not here. In this situation, all that the legislature has done is prescribe a default rule for what to happen in the event that the deadlock that the delegates saw 130 years ago happens. In terms of where the line would be drawn in some future cases.
And under your view, is there any constitutional hook for the courts to get involved in the administration of elections in general?
Very limited, Your Honor.
Due process, equal protection?
Due process and equal protection, I'm sure. I think there needs to be a strong showing of a constitutional violation.
Corruption or fraud, let me ask you, if the presumption you're talking about, the default, if we were to decide it fails, for whatever reason, does that, for mail-in ballots, does that mean that the in-person presumption would also have to fail?
I'm sorry, Your Honor, I didn't quite follow. If,
You were arguing that there's a presumption, the default position that it's valid, right? So I'm just saying, if we thought that that failed for whatever reason, if we agreed with them, does that mean that when it comes to the in-person presumption that was described by the Attorney General, that that too would have to fail?
I think it, Your Honor, I think it would, and that would be an awful result, and it would be contrary to a century or more of the way elections have been held and what presumptions apply. I fear that that might be the next argument, that if this presumption doesn't apply, then presumably that could form the basis for a challenge to the in-person procedure. And remember, the point of elections is not to nitpick technical defects. What the legislature did with Chapter 763 is try to limit the challenges to technical defects. The idea, even expressed by the delegates 130 years ago, is enfranchising voters and allowing every valid ballot to be counted. That's what the legislature did with Chapter 763. Thank you.
Thank you.
Counsel, can I ask you on the separation of powers question? You point, I think, to Article 6, Section 7. Are there any other constitutional provisions that you would direct our attention to in terms of sorting out the answer to Judge Garcia's question?
Yeah, so the question is, where is the line for the judiciary?
So where in the Constitution do we look in addition to Article 6, Section 7A?
That gives the court its plenary jurisdiction, but I think we look at the separation of powers doctrine in not only the state, but also the federal constitution.
So just generally, if we stick to the state constitution, if we could. So the separation of powers doctrine as a general matter, but I just want to make sure there aren't any other specific constitutional provisions you would point us to.
Well, I believe it does deprive litigants of their due process rights in addition. And that is absolutely the issue when we talk about the administrative cases. You know, each one of those cases, though they involve the civil service department, the court arrived at a conclusion that there must be judicial.
Who are the litigants in that argument? It's not the voter, right?
No, they're not voting cases, but they apply to all administrative
No, I'm saying in your argument, maybe I misunderstood you. It says the litigants' due process rights would be affected or offended. So who would that be? Because in these examples, it's not going to be the voter because the ballot is counted.
Well, the litigants here, right, the appellants are comprised of party chairs, candidates, voters. These are individuals who no longer have the ability to lodge objections at a canvassing. They're merely poll watchers.
And
A single poll watcher has
Where's
no,
the constitutional right to that?
to lodge
To
objections.
object.
There is no constitutional right to lodge an objection, but they are merely now poll spectators. The constitutional right is Article 2, Section 8, which guarantees equal representation. The commissioner is the last bastion of the guardianship of the rights of their party. The legislature, right, the question was, where will the legislature draw the line in terms of how it will regulate? It has plenary authority under Article 2 to regulate the time.
It's not really equal representation anyway at the end of the day, because it's only the two the two parties who get the most votes. I mean, there are other parties.
It secures the
Right,
equal
in that way.
representation
So
of the two highest vote-getting parties.
It's a little
correct.
bit of a soft argument anyway.
Well, no, because the commissioners are all that are left to uphold objections. Right now, review is illusory at best. And the hook here, when we talk about what does the Constitution guarantee, is what this court arrived at in the matter of Stefanik versus Hochul. It's this court's role to determine what our Constitution requires, even when the resulting analysis leads to a conclusion that may be unpopular. It's emphatically the province and the duty of the judicial department to say what the law is. Here, the legislature has invaded that authority. It said the judiciary doesn't matter. We're going to tell you how votes are cast and canvassed, and you have no say. 16106 sub 5 doesn't give the judge any
It's only for a
ability-
it's for a small group, right? I mean,
for 61
many, you already went through it. By statute, there are some that are presumed defective and they get put on the side. This is not, I'm not talking about the ones that are curable and get sent out. I'm talking about the ones that are just marked defective from the get-go, the threshold determination. Those are held over, right?
It may be a small group of votes, but even one vote that shouldn't be cast and canvassed is one vote too many. The respondents cite to commissioners' affidavits that say this happens only in 0.01% of ballots cast. Well, if it's such a small problem, then there's really nothing to worry about for the state to deal with this should 92092G be stricken by this court. The injury to my clients, the injury to the appellants, is far greater than any perceived inconvenience to the respondents. And I will just add that there are no other safeguards to this process. Any discussion about criminal culpability, liability,
Well,
quo
let me
warranto
just,
actions.
the light has gone out, so I don't know how long it'll take you to answer this, hopefully not much time. I just want to understand, so then under what you would say should be the regime, when one commissioner objects and says, I think it's invalid, it shouldn't be counted, your regime, what should happen? That gets put in a pile, and then if someone has an objection, maybe it'll go to court, or it always goes to court?
So what should
your
be,
process?
what
Yes.
should be the remedy should this statute be
What's
stricken?
the protocol, yes?
The protocol, I think, would be to utilize 92098E, which puts this into the bucket of ballots that were determined to be invalid. That allows either side to then bring an action for judicial review of those ballots. But I will also say that if 92092G is so intertwined with the rest of Chapter 763 of the laws
Wait,
of
before you go
20
down that road, so if I'm understanding you correctly, that could mean the litigant that you were talking about that doesn't have this opportunity to challenge, might never challenge, correct? They
They
might
may-
never end up before a judge.
They may never. As was the case before the statute was put in place, ballots were preserved for review for 3 days. Most times, those cases were never litigated. Most times, those litigants never took the opportunity to go to
Well,
court.
how doesn't that offend the Constitution?
Because they had the
How
right.
is it the judiciary isn't denied the opportunity to exercise the authority you say they've been granted under the Constitution in those cases?
Because the ballots were preserved for review. There was that 3-day window where one could go to a judge and get an order to show cause signed and bring an action to determine the validity or the invalidity of that ballot. There is no longer a preservation. As the Supreme Court noted, Saratoga County, judicial review is left to be illusory at best. There are no other remedies. There is no ability for these individuals to seek judicial review of their administrative grievances. And any criminal statutes or quo warranto actions are post hoc remedies that have nothing to do with determining the results of the election. The tie should not presumably go to the voter. The tie should be preserved for the courts.
Thank you.
When ballots have not been properly cured, one commissioner can validate those ballots for whatever reason, whether there wasn't a witness to the signature mark, whether it's not the appropriate signature, whether someone comes back and says, oh, I'll sign it now. When it comes back, one commissioner can say, I like that
But
signature.
what if it doesn't come back? What if they send it out for cure? I think the point of opposing counsel was no signature, we send it out for cure, it never comes back. What happens?
If it never comes back, there's nothing to review at that stage. But that's a different scenario than the one we're concerned about, which is when decisions are,
But then it would have to come back, and then there would be a disagreement over the signature that came back.
or there's no witness to the mark. That's another one. Or that the voter already voted
No
in another
witness to the
state.
mark is something you can disagree on?
There has to be a witness to a mark, like an elderly voter in a nursing home.
Okay.
So they have to have a witness to the mark. The voter cannot show up under this regime, as they can currently say, that's not my signature and I didn't vote. Don't count this. It was fraudulently placed there. Under this system, the vote gets counted no matter what. There's no redress for that voter to ever come back in and say that. With respect to in-person voting, even when you show up in person and do that affidavit ballot, because let's say the two inspectors don't agree that this is the right person. Now, at least you have the advantage of being in person, you can show who you are. If there's still disagreement and you vote by affidavit, It still has to be reviewed by two
But
commissioners.
what if the signatures allegedly don't match in in-person voting? What happens?
They go to affidavit ballot,
They do.
but it doesn't automatically get counted. It has to go, it gets counted afterwards, and that's happening even today. That's what happens.
And then that can be challenged.
Again, it depends. If there's a split, it gets counted. If they agree it doesn't match, then one party can go to court then, under this regime. Stapleton was decided before the Constitutional
I'm
Convention.
sorry, it'll get counted before it goes to court?
Pardon?
It'll get counted before it goes to court? I'm sorry, I missed that part about
If
the
it's
in-person.
split, let's say the affidavit,
Yes.
it comes back.
Yes.
And this happens even today in closely contested elections. The
For the
affidavit ballots,
in-person.
if split.
For
get
the
count-
in-person?
Pardon?
For the in-person? Are you talking
Yes,
about the
yes,
in-person? Okay.
yes, and that's why I wanted to correct that. It's
Okay.
not like automatic, oh, you show up and you have carte blanche to vote. There
Okay.
is still a regulatory process, and again,
You take the oath, you fill out the affidavit, you're
Yes.
saying then someone can still challenge it? Is
yes,
that what you're saying?
Yes.
And then what happens? I'm sorry.
commissioners have to decide.
Okay, and if they
It
split,
counts.
it counts.
If it's unanimous, no problem. If it's unanimous, no good, you can go to court. I see my light is on. I thank you for your attention.
Thank you.